Good evening and welcome back to Courts Today by Live Law. This is your host Urvashi Chauhan bringing you the latest updates on the legal front. This is your go-to source for all things legal. Let us start. Let me start by giving you a brief update on the day 7 of the Constitution Bench hearing the case relating to the minority status of Aligarh Muslim University. Senior Advocate N.K. Kaul continued his arguments today on behalf of the respondents. He said that the British government established Aligarh Muslim University after dissolving the AMU college. The decision was made by the central government and not the Muslims. Even though the term established has been replaced with university, it does not change the historical fact recognized by the Basha's judgment. He said this fact was not declared as law by the Basha judgment but was acknowledged as true. He further argued that legislative history cannot be altered. Changing the definition of university and removing the word establishment will be modifying historical facts. To this, Justice Khanna said that the legislature could make laws with retrospective effect. Suppose they were of the view that they had mistaken notion to use the word established there, they could have always removed it because the court acted upon that basis. CJI Chandrachud today mentioned that AMU was also set up on the same pattern as BHU, that is Banaras Hindu University. That Hindu leaders were given an undertaking that AMU would be on the lines of BHU. To this, Senior Advocate Guru Krishna Kumar replied by referring to Section 8 of the AMU Act 1920, which says that it is open to all. Teaching of theology was for those who wanted to study. Their choice meant an institution for the development of that minority, be it linguistic or religious. Further, Senior Advocate Vinay Naware made his submissions on the scope of reference, the facts and law of 1920 and the interpretation of those facts. This was followed by Senior Advocate Vikramjit Banerjee elaborating on B.R. Ambedkar and decision in Bal Patil's reference on the question of minority and history of how minorities are formed. The court will continue hearing the matter tomorrow as the petitioners will present their rejoinder arguments. You can watch the live proceedings of the hearing on our YouTube channel. The next important update is on Gyanvapi Vyasji Tehkhana. The Varanasi district judge today directed the district administration to make appropriate arrangements within 7 days for Hindus to conduct worshipping rituals inside one of the sealed cellars or tehkhana or basement inside the existing Gyanvapi mosque complex. Worship at the spot was stopped in 1993. The order was passed in an application moved by Hindu plaintiffs seeking the right to worship in the tehkhana. The matter relates to Somnath Vyas Tehkhana inside the Gyanvapi mosque premises. It has been alleged that until 1993, the Vyas family conducted religious ceremonies in the basement. However, in compliance with the directive from the state government, the religious practices were discontinued. I must tell you, Varanasi district administration had taken over the possession of the southern cellar within the Gyanvapi mosque complex on 24th January. The Bombay High Court has today delivered a split verdict on the pleas seeking to strike down certain rules of the IT Amendment Rules of 2023, which empowers the central government to establish a fact-checking unit to identify any fake, false or misleading information about its business on social media platforms. Social media intermediaries like Instagram and Facebook would either have to take down the content or add a disclaimer once the government's FCU identifies the content on their platform. The petitioners, that is political satirist Kunal Kamra, Association of Indian Magazines, News Broadcasters of Digital Association and Editors Guild of India, had claimed that the rules could lead to arbitrary censorship of content as it could be blocked, taken down or social media accounts could be suspended or deactivated. However, the Ministry of Information and Technology claimed that it would be in public interest for authentic information related to government's business to be ascertained and disseminated after fact-checking by a government agency so that potential harm to the public at large can be contained. According to the split verdict, Justice Gautam Patel has ruled in favor of the petitioners, and Justice Neela Gokhale has upheld the amendment. The matter will now be placed before a third judge as per the Bombay High Court rules. Meanwhile, Solicitor General Tushar Mehta assured the court that the FCU will not be notified for another 10 days. Court has granted liberty to the petitioners to move an application before the appropriate forum for seeking any further extension of the protection. And now let me tell you, a Delhi court has been informed that the accused persons arrested in the UAPA case registered over security breach in the parliament in December last year were tortured, forced to sign various blank papers, and were given electric shocks to confess the alleged crime and their association with certain political parties. The submission has been made in an application filed before Additional Sessions Judge Hardeep Kaur of Patiala House Courts by 5 out of 6 accused persons. The application states that the accused persons were forced to provide their passwords for social media accounts, emails, and phones. It adds that those conducting polygraph or narco tests pressed 2 accused persons to name a political party or leader about their alleged involvement. All the accused persons were produced today before the court, after which their judicial custody was extended till 1st March. The court listed the application for further hearing on 17th February and asked the Delhi police to file its response to the same. You must have seen the visuals coming from the Union Territory of Chandigarh, where high drama unfolded yesterday. This was after the presiding officer at the Assembly Hall of Chandigarh Municipal Corporation declared 8 votes of Congress and Aam Aadmi Party councillors invalid, paving the way for the BJP candidate's victory in the mayoral elections. The Punjab and Haryana High Court today sought response from the Chandigarh administration and the Municipal Corporation of Chandigarh on a plea filed by AAP councillor Kuldeep Kumar alleging vote tampering in the mayor elections. While issuing notice on the plea, a division bench of Justice Sudhir Singh and Justice Harsh Bangar granted 3 weeks' time to the respondents. However, it declined the request made by senior advocate Gurminder Singh, appearing for the Aam Aadmi Party councillor, to dissolve the functioning of the office until further orders. Also, the council appearing for the Union Territory government informed the court that the record of the election has been preserved in the strong room. The Aam Aadmi Party alleges that the presiding officer in most flimsy manner declared that he did not want any assistance from the members nominated by the parties contesting the election and that he would count the votes himself. It is claimed that there were 3 baskets in front of the presiding officer, one for the candidate of Aam Aadmi Party, the other for the candidate of BJP, and the third for invalid votes. It has been alleged that the presiding officer shuffled the casted votes from one basket to another to create confusion and compromise the election process. And lastly, the Supreme Court, while convicting an advocate in a 17-year-old criminal contempt case, reiterated that an apology must be evidence of remorse for the contemptuous acts. It must not be used as a weapon to purge the guilty of their offence. Further, an apology lacking sincerity and not evidencing penitence cannot be accepted. The division bench of Justices Vikram Nath and P.S. Narasimha was hearing an appeal of a lawyer who was convicted of criminal contempt by the Delhi High Court in 2006. He had inter alia made improper and reckless allegations against the judges. Moreover, he continuously failed to appear before the High Court. Multiple ways were adopted to secure his presence without any avail. Finding him guilty of the criminal contempt, the High Court had sentenced him to simple imprisonment for 3 months with a fine of 2,000 rupees. Thus, he filed the instant appeal before the High Court. While admitting the criminal appeal in 2007, the Apex Court had granted an interim order to stay the operation of the High Court order. However, on more than a dozen occasions, the court noted that the listed cases were either adjourned at his request or because of his absence. Given this, the court vacated the interim order last year. After perusing the submissions, the top court has concurred with the view taken by the High Court. It also observed that the apology rendered by the appellant was not bona fide and was a mere lip service. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.